Just 2 miles from my own front porch, right here in Meade County, Kentucky, a man was shot dead in January of 2024. The shooter says it was self-defense. The judge says, hold up, pump the brakes, maybe not. And if that judge is right, then none of us here in Kentucky are actually protected by our self-defense laws. Now, this is going to be a very intricate breakdown of Kentucky's self-defense laws and the nuanced language that decides whether you get to walk free or you got to fight for your freedom in court. If you've ever wondered what these laws really say, what they actually mean, and how they play out when your life is on the line, then stick around, because the details in a case like this matter. And if they don't matter to you now, they will the moment that somebody threatens you or your family. Self-defense immunity is supposed to be a simple concept. If you lawfully protect yourself, your family, or your property, the state shouldn't be dragging you through a criminal trial. It's not some legal loophole. It's a promise that good people won't be destroyed for doing what they had to do. Kentucky's law says this, and I ask you to look these all up yourself. I'll give you the statutes. Go read them with your own eyes. KRS 503.050, subparagraph 4. If you're justified in using deadly force, you have no duty to retreat. And here's what justified means under Kentucky law. The use of deadly physical force is only justified when you believe it's necessary to protect yourself against death, serious bodily injury, kidnapping, sexual assault, felonies involving the use of force, or under specific circumstances outlined in KRS 503.055, which is the statute that covers Kentucky's Castle Doctrine. And what that says in plain English, and again, I ask you to go read it with your own eyes, if someone is unlawfully and forcibly entering your home, your occupied vehicle, or trying to remove someone from it against their will, the law presumes that you have a reasonable fear of death or great bodily harm, which means that you don't have to prove that in court. It's presumed that you feared death or you feared great bodily harm. It even says if they break in by force, the law presumes that they are there to commit a violent crime. You don't have to prove that. If somebody's breaking into your house, that presumption is there by the law. It's meant to protect law-abiding citizens. But here's the kicker. That presumption doesn't apply, of course, if that person had a legal right to be there. And this makes sense to me. You can't use Castle Doctrine in a domestic dispute. Or you can't invite your friend to your house and get into an altercation and claim the Castle Doctrine immunity. If there's no restraining order, no contact orders, it doesn't apply. If they're there legally, it doesn't apply. KRS 503.080 says that you can use deadly force to protect your property from theft or force. That's the theory anyway. Now let's talk about what the actual reality is. This happened right here in Meade County, just a few miles from where I'm sitting right now. David Gex's residence. Richard Hernandez also lived on this property, off and on, I guess, for the couple years prior to this event. He was living in an outbuilding just a few yards from the main residence. That's what the reporting says anyway. And that detail is going to matter when we talk about the Castle Doctrine. And here's something that you're not going to probably find in the quick news blurbs. Hernandez had a documented history of violence against Gex. Gex had a black eye at some point. There was a knife attack. It's a muddy history with these two. And on January 14th, Hernandez took Gex's truck without his permission. Gex called him, was texting him, told him not to take it, told him he wanted him gone, bring the truck back. And a witness riding with Hernandez, someone who didn't even know Gex, said she never saw him point his rifle at him, never saw him threaten him with it. But what she did hear was Hernandez cussing him out, berating them as they walked toward Gex's home. So picture this in your mind. It's a cool January, icy outside. Gex takes the keys out of the truck and he turns toward his door, and Hernandez is right there, hurling insults, pushing the confrontation even higher, escalating the situation. Gex says that Hernandez charged him from 6 feet away, took one shot, front-facing, and then later called 911. Gex wasn't fleeing, he wasn't hiding, he wasn't trying to evade the police, he was calling for help. And now here's why the judge is denying the immunity in this case. First, the judge says that Hernandez might have still had a legal right to be on that property. That alone is enough to block the Castle Doctrine presumption of reasonable fear. And that's understandable. That's a gray area. If he had permission to live there at one point and then didn't, and then did and didn't, I get it. Second, though, he says Gex might have been the initial aggressor. Why? Because Gex armed himself, went outside, and he confronted Hernandez when he came back with a truck. Now, in the judge's eyes, this could be seen as provoking the encounter. And this is what I don't like here. Should we really consider someone an aggressor just because they're armed? Doesn't that put every Kentuckian who legally carries a firearm every single day in a bad position? Are we all not the initial aggressor the moment we've got a gun on our hip, even if we never point it, threaten anyone with it, and it's just purely there for our protection? Here's where it gets a little bit tricky. Kentucky law says that if you're not the aggressor, you have no duty to retreat. But if the court says that you are the initial aggressor, or they believe there's probable cause that you are, the rules change a little bit. Under KRS 503.060, you must completely withdraw from the conflict and clearly communicate that you're ending it before you can claim self-defense. So an example of that, me and somebody get in a fight. Okay, now the fight's over and I'm running away and I'm trying to just get away from the fight. And while I'm running away, the guy's chasing me down and he catches up to me. And then I end up killing the guy. I clearly withdrew from that before using that deadly force. That's what the law says. And the judge says in this case that Gex didn't effectively withdraw before firing. Third, and this part's important, all the prosecution needs at this stage is probable cause that the force wasn't justified. It's a super low bar, not beyond a reasonable doubt, not clear and convincing evidence, just enough to send you to trial. And here's what I see as the danger. We have an independent witness, someone who didn't even know Gex, saying she never saw him point the rifle at Hernandez. She never heard him threaten anyone. But what she did hear was Mr. Hernandez cussing him out, insulting him, and instigating this argument. And yet there's no immunity. Kentucky law says if you reasonably believe deadly force is necessary to protect yourself from death or serious injury, you can meet force with force, period. No duty to retreat. But if a judge can look at a case like this, with a documented history of violence between these two, a witness confirming the other man was the aggressor that night, and still say, we're going to trial, then what does the self-defense immunity even mean? What kind of scenario would allow for this immunity to apply? If this is the standard, any law-abiding citizen who uses a gun to protect themselves could easily end up in handcuffs, name in the headlines, and their future in the hands of a jury, even when the law is supposed to keep them out of the courtroom in the first place. If self-defense immunity doesn't protect a man from prosecution in a situation like this, with prior assaults on record, a witness saying that he wasn't threatening anyone, and the other man doing the provoking, then can anyone imagine a case it would cover? Because I can't. And if that protection is this easy to strip away, that should scare every single one of us. If you believe the law should mean what it says, share this with somebody. Talk about it with somebody. Because the next time, it might not be 2 miles from my house. It might be in your front yard.